Thank you. Please be seated. Okay, we're here on the case of Center for Sustainable Economy versus Washington State DNR, 22-2-15-16. So I'm sorry, we have your name, please.
My name is Krista Thompson. I
Okay.
represent the Department of Natural Resources.
Good afternoon, Your Honor. I'm Claudia Newman, and I represent the appellants. Center for Sustainable Economy and Save the Olympic Peninsula.
Pardon me.
The Center for Sustainable Economy and Save the Olympic Peninsula.
Thank you. Just a moment. Okay, I've read through all the documents that you've submitted. I'll be honest right up front, the record that you've submitted is over 17,000 pages. I have read a number of those documents. I tried to piece together what seemed to be most relevant after I read your briefs and replies and so on. And I looked through the index and picked out some other stuff to look at too. So I feel like I've looked at a lot of that, but I've not looked at 17,000 plus pages. Okay, so this is the appeal by the Center for Sustainability of the approval of these timber sales and the SEPA determinations of non-significance on each of the sales. And we have another hearing this afternoon at 3:30, so we're going to have to be finished by then. I thought we'd start by up to 45 minutes each, and Ms. Newman, you can split your time between your argument and rebuttal however you wish. So, and I'm going to have, I've made a list of some questions I'm going to have depending upon what you each address in your argument. So Ms. Newman, yeah, go ahead.
Yes, thank you, Your Honor. Would you like me to approach or just?
Yeah, if you could, up to one of the speakers, if
Thank
that's
you.
all right.
I'd like to have 25 minutes for my opening and reserve the remainder.
Okay, and maybe,
Oh,
yeah, the speaker I think is over there.
oh, okay.
Yeah,
Okay.
yeah, so, yeah, go ahead.
And as an aside, thank you very much for reviewing everything. It's much appreciated. This case is about DNR's failure to evaluate the climate change impacts of site-specific logging projects, despite that it's required by the State Environmental Policy Act. And it's actually a very simple, straightforward legal issue presented to this court. When DNR was conducting SEPA review of the timber sales, the DNR responsible official said, "We are not legally required to conduct any review of climate change impacts." And they didn't do it at all. So it's not about whether the responsible official did an adequate job of reviewing the climate change impacts. It's not about whether DNR previously reviewed climate change impacts in broader policy documents, but it's a question of whether they were required to conduct a review of climate change impacts at all at the project-specific level. And we're here with, it's a judicial review case, and so the decision that the court is reviewing today is the decision that DNR, that the responsible official made that said DNR is not legally obligated to conduct any review of the climate change impacts. And we have a very simple request for relief with this appeal. We're asking the court to remand the matter to DNR with an order stating that they are required to do that review. And requiring that their SEPA responsible official engage in an assessment of the climate change impacts that these timber sales will have. Just to provide a little bit of context, I'm going to describe some of the basics with respect to the State Environmental Policy Act. SEPA, which I'll refer to it as SEPA, which I live and breathe and sleep. SEPA requires that agencies prepare an environmental impact statement for major actions that will have significant adverse impacts on the environment. And elements of the environment are identified in the regulations. We have wetlands, we have air quality, we have water quality, traffic. There's several different elements of the environment. And the focus of this appeal is the air quality, emissions, climate change impacts, which is one of the elements of the environment. And that's not disputed. And the first step in the process for every agency is an EIS required? Do we need to prepare an EIS? And that's called a threshold determination. And the answer is either a DNS, a determination of non-significance, which means no EIS is required, or a determination of significance, which means yes, an EIS is required. And there's a basic fundamental requirement that's been repeated by the courts over and over again with respect to a DNS review, when the court is reviewing a DNS, which is the situation in this case. In this case, the state DNR issued a determination of non-significance for both of the timber sales, which means that an EIS was not required. And for the DNS to survive judicial scrutiny, the record must demonstrate that environmental factors, and for us that's climate change, were considered in a manner sufficient to amount to prima facie compliance with the procedural requirements of SEPA, and that the decision to issue an DNS was based on information sufficient to evaluate the proposal's environmental impact. So what I just described, there's also with SEPA, one last comment just about the basics of SEPA, is that there's a procedural authority under SEPA and there's a substantive authority under SEPA. And the procedural authority is the process of actually engaging in environmental review. There's no outcome requirement. They just have to basically identify and assess and disclose the environmental impacts, go through a public process that allows the public to also participate in that. And the whole goal of that process, the procedural authority, is simply to inform a decision maker before you approve a timber sale. We want you to know what the impacts are going to be, the environmental impacts are going to be of your decision. And the decision maker can approve it, but SEPA is just there to inform that decision maker what the impacts will be. The other authority is called substantive authority, and that is the authority to actually attach conditions to a project. And as an example, if you have a tall building and there's a setback of 10 feet that's required under the code, SEPA allows decision makers to increase that setback by 20 feet if there are significant impacts caused by the building that they think is appropriate to increase. So that's substantive authority because they can actually attach mitigation to a project. So with that background, I want to circle back to what DNR did in this case with these two timber sales. So what I have here are the excerpts from the environmental checklist. An environmental checklist is a document that the agency uses to collect the information to determine whether they're going to issue a DNS or a DS. So they're basically doing their environmental assessment and collecting information. And for the Goodman 1 timber sale at record 7232, there's a question in the environmental checklist that says, what types of emissions to the air would result from the proposal during construction, operation, and maintenance when the project is completed? If any, generally describe and give approximate quantities if known. So that's the question at 7232. This may
And
be,
and
you
I'm
might have
sorry.
the Taylor.
I'm
I
sorry,
can start
that's-
with Taylor if you have that handy. I'm sorry?
Well, okay, you were just talking about the Goodman checklist.
Yeah, the Goodman checklist. Oh, you do have that?
I have
Okay.
them each here, and what was it you were looking at?
7232 is the record number, and it's the answer to the air section, which is page 10 of the checklist, if that's the Goodman.
Yeah, in mine it's page 11, but yeah, go ahead. It's
Oh,
air,
okay.
air, yeah, go
That's
ahead.
interesting. And so there's a question about emissions, and the answer to that question is minor amounts of engine exhaust from logging and road construction equipment and dust from vehicle traffic on roads will be emitted during proposed activities. If landing debris is burned after harvest is completed, smoke will be generated. There will be no emissions once the proposal is complete. Now, this is the section where you would typically address climate change emission, greenhouse gas emissions from a project. So you see they didn't even mention it there. And then if you look at the Taylor Downhill Sorts environmental checklist, which is record 8557, you'll see that it's word for word exactly the same. It looks like they have a boilerplate answer there, because when they're asking what types of emissions would result from the proposal, again, they say minor amounts of engine exhaust. I won't read the whole thing, but it's exactly what I just read. And then, so I just want to emphasize that this is the analysis that the responsible official engaged in and that the public reviewed during the SEPA process. And there's no mention of climate change impacts at all. So then when members of the public expressed concern that there was no analysis of climate change impacts, the responsible official in Taylor Downhill Sorts said, it's at 8540, record 8540 is the answer here. This is the DNS for the Taylor Downhill. While your letter does touch on some specifics of this proposed timber harvest, the bulk of your comments are directed toward the broader policies and plans that guide our management at the statewide level. We conduct SEPA analysis at the project level for individual planned timber harvests. We conduct environmental impact statements before adopting new blah, blah. I'm going to skip that. The agency does not agree that the analysis you recommend is appropriate for including in the project level checklist. So what they're saying here is, we don't think it's appropriate to analyze or look at the FEIS for those broader policies. This is project level analysis. So you're talking about the plans and the broad policies, and we don't think that's appropriate. And then they said, at this level of project review, the appropriate form used is the Department of Ecology's environmental checklist. At this time, SEPA environmental checklist does not include analysis of climate impacts. So what they were saying there is, we are not required to analyze climate change impacts. So that's what the responsible official did. And we appealed that and argued in our opening brief that, yes, indeed, they were required to. That was the basic argument in our opening brief. And DNR's response brief didn't dispute that. So right now with the court, there's no dispute that as a matter of law, the climate change impacts are an element of the environment that need to be assessed at the project level. So the responsible official's conclusion that that wasn't required was incorrect. But we did get new reasoning from Department of Natural Resources in the response brief, where they introduced a new justification for the failure to assess climate change impacts that was different from what the responsible official said. In the brief, DNR said it conducted review of climate change impacts in the EISs for these broader plans. They referred to the Olympic Experimental State Forest Land Plan, which was 2016, and this is the FEIS for those plans. The Sustainable Harvest Level Alternatives, 2019 FEIS, and the Long-Term Strategy for the Marled Murrelet, 2019 FEIS. And I just want to emphasize the responsible official did not mention these plans. And in fact, as I just said, the responsible official for Taylor said that analysis of those broader plans was not appropriate at the project level. So it's almost the opposite of what the responsible official said. And it is true under SEPA that a state agency can reflect back when they're doing their project review, specific review, they can incorporate the analysis from broader policy plans. It's called phased review. It's commonly done. But the problem in this case, it's different from typical phased review, is that phased review has two phases. The first phase is environmental review of the broader policies. The second step, phase 2, is environmental review of the site-specific project. And they skipped the second step. They skipped phase 2 entirely. So the DNR brief, if you read it again after thinking of it through this context, you see that there was no environmental review, and they're asking the court to just say, okay, they did the environmental review before, so they don't have to do it again for the site-specific project. But that's not correct. They did it before. They do have to do it again. They're allowed to look at what they did before, but the responsible official actually has to say that they're relying on that and go through the process of assessing the climate change impacts, which the responsible official didn't do. And so that's why this is a very simple case, because there's a lot of discussion in DNR's brief where DNR's engaging in the analysis that the responsible official was supposed to do. And so that's why it may feel, I mean, when I'm looking at that, it's difficult for us because this is what we wanted the responsible official to do, but we didn't have an opportunity below to respond to. Now DNR is making an argument. We're kind of sandbagged because the record is closed and we don't necessarily have all the evidence we need or ability to respond to that with a closed record. And so we're asking the court to remand this matter so we can have the conversation about impacts via the proper SEPA process and do a climate change analysis of the timber sales that didn't happen below, rather than in front of this court. And I want to just, I don't know if my time is up. I haven't been paying close attention, but I guess I'm quicker than I expected.
Almost 20 minutes.
Okay.
That you've used, yeah.
I just wanted to say, we did in our opening brief, this is going to be a little bit, I noticed in our opening brief we said to the court, please rule that there will be significant adverse impacts caused by this project. And I think upon, that is basically stepping into the shoes of the responsible official. And when I received DNR's brief in response to our opening brief, it became evident that this court should not step into the shoes of the responsible official because that analysis, there's no decision, the court doesn't have that decision in front of it to review. The court would instead be making a decision that the county is supposed to, or I'm sorry, the agency is supposed to make, that DNR is supposed to make. And so we request that the court remand this back to saying, yes, you're supposed to consider climate change impacts, and just, opening up the door to not telling them what their decision is supposed to be in the end, but instead just telling them this is something you need to do at this process, and then opening it up for a new proper public process under SEPA to conduct that SEPA analysis of climate change impacts for the specific timber sales. And with that, I conclude.
And the same relief is being asked with respect to both sales.
Exactly,
Right,
yes. And yeah, it's almost identical. There are a few differences I'd be happy to talk about if you're interested, but
Yeah, that's okay.
Same relief for both. Thank you.
Thank you. just a minute.
Good afternoon, Your Honor.
Okay.
My name is Krista Thompson. I'm an Assistant Attorney General. I represent DNR in this matter. Just one moment. Petitioners have talked about two errors that they allege DNR made. DNR said that we're not required to do a climate analysis, and they are asking the court to answer that hypothetical question. In general, what DNR is supposed to do under SEPA is to analyze any probable significant adverse impact. If that involves climate change and releasing greenhouse gases, that would be properly included in the SEPA analysis. However, in the context of these two timber sales, which is the decisions that they are appealing, this court should only reverse DNR if there's a showing that climate change is the result of these two timber sales. If there's a probable significant probability that these timber sales will negatively impact the environment in terms of climate change, and then this court should remand to DNR. However, the petitioners presented very little materials during the comment period. They referenced by citation a few articles that of two DNR was able to obtain, the rest DNR did not obtain until after the comment period. And none of those articles support their contention that the emissions associated with wood products over time have any impact on the climate. In fact, everybody from the UN down to the state of Washington looks at carbon on forestry in the context of a sector-based analysis. They say, let's look at the amount of wood removed. Let's compare it to the amount of wood that grew during that time period. They look at the emissions from the wood products and the processing, and they compare it to the sequestration that occurs on the forested land. Always, when you have a situation of sustainably legal harvests, you have net sequestration of carbon, because trees take up the carbon. And when you cut down the trees, they are taken to a mill, processed into paper products or hardwood products, and then they're used and discarded. If they're discarded illegally, then they emit. If they're sent to a sanitary landfill, that landfill is capped and they may not emit carbon for many decades. If they are put, like this furniture here, this furniture is emitting carbon because it's aging and decaying. One day this will be sawdust. I don't know if that'll be 100 years from now or 10 years from now, but it is emitting carbon. So they take that into account and then they do an offset. Look at the emissions over time, look at the sequestration over time. Is there an offset? And always there is an offset. And that approach was in DNR's head when it read the center's comment letter. So DNR really didn't understand until much later what they were asking us to do. They just said, calculate the emissions. It's like, well, what do you mean by, the emissions from the wood? It's not released immediately upon harvest. It's released over time. And it depends on a variety of factors of how the wood is used. So that it's not impossible to do. You can do the calculation, and in fact, DNR has done the calculation on a regional basis. But DNR did not believe that carbon emissions analysis was required for the individual timber sales because it's not useful information to the decision maker. Emissions of carbon dioxide alone is not a toxic substance. Carbon dioxide coming from trees that are decaying is natural. Carbon dioxide, there's carbon dioxide in this room right now. It's natural. The problem is because we burn fossil fuels and have been doing so since the early 1800s or so, we now have too much carbon in the air. It's not because of forestry and trees. It's because of the burning of fossil fuels. And just to calculate the figure of, say, 48 metric tons, or 48,000 metric tons, or 4,800,000, that doesn't tell the decision maker anything when you're talking about forestry. What you need to do is look at the quantity of wood that is harvested over time and compare it to the amount of wood that is growing over time. So DNR really didn't understand what they were talking about. They were confused. I don't know, we did this already. We did this at the policy level. And they were right. DNR did not incorporate, by reference, those environmental impact statements. But I say that doesn't matter, because in this case, plaintiffs didn't come forward with information that shows that emissions from these timber sales, or timber sales in general, impact climate change. Now, what is going on in the Amazon, where they are taking out hundreds of miles of the rainforest, that is something that is affecting climate change. But as their materials that they cited, on the other hand, supported the notion that sustainably managed timberlands that produce timber for harvest always sequester more carbon than is emitted. Let's look at the, I'm going to go through a brief chronology of the procedural events in this case. There were two timber sales. They overlapped. The chronology overlaps, so it's a little confusing. In November of 2021, DNR issued a determination of non-significance for the Taylor downhill sorts. The public comment period closed on December 2nd, 2021. CS, the Center for Sustainable Economy, submitted comments on the sale at the very end of November 30th, 21. That was within the public comment period that closed on the second day of December. At the January 4th board meeting, and in this case, it's not the, they have appealed the decision that the Board of Natural Resources made to sell timber. That's the basic decision that they're challenging. There is also a forest permit process that involves SEPA, but they haven't challenged the forest permit in this case. They are challenging the board's decision to sell timber. Mr. Talbert appeared at the board meeting and made his arguments that emissions need to be considered and that DNR, that you have to do this, you have to do this. The board listened to that and they asked DNR questions about what about this climate change? And the answer was, we did these analyses as part of our regional decision-making process last year when we established the sustainable harvest level and hand in hand the complementary policy for the conservation of the marble murrelet when we amended our federal habitat conservation plan. we looked at those analyses. I think it was Dr. Brown said, well, forests sequester a lot of carbon, far more than they emit, and DNR staff said yes, perhaps fivefold. He couldn't remember off the top of his head. So the board was aware of their recent decision. The board was aware of the SEPA documents that they had to review. And so that is why those things are included in the record. Now, they may not have been incorporated correctly under SEPA, but the focus is, did plaintiffs bear their burden, appellants bear their burden of coming forward with documents that say, hey, everybody's doing it wrong. You need to calculate emissions at the individual stand level and not do carbon offset. Now, in the Goodman sale, the determination of non-significance was made on December 15th, 2021. On 2021, the center submitted comments. And then on December 30th, 2021, comment period closed. On January 6th, the final notice of determination was made, and DNR retained the DNS. It was not until January 26, 2022, after both comment periods had ended, that they submit a letter reiterating the same comments they made in the letter, but including materials that they wanted to review. So, my position is, only if they cited those materials in the pre-comment letter should they be talking about, adding these to the record. Now, I've included them in the record, but really, technically, under SEPA, it's too late for them to provide materials. Now, in this case, I'm not particularly bothered, because those materials support DNR's position. They talk about how timberlands in Jefferson County sequester far more carbon than is emitted. They have, let me go through the materials. The materials that were referenced in their two comment letters that were timely were the Talbert 2017, I think it's Law 2018, Smith 2006, Turner 2004, and Harris 216. And then another, which actually it was the DNR report on carbon storage and wood products by someone named Christensen. If you look at the article that they submitted to make their case, the Harris article, in Harris, the author used satellite data to derive information regarding carbon stocks. This author concluded that forests in the United States sequester more carbon than is emitted through disturbance of the forest. Disturbance means insect mortality, forest fires, and logging. He looked at it at the countywide basis and said, there are carbon gains in all states that exceed, the carbon gains in all states exceed carbon losses. He looked at it at a big point of view, using satellite data. Now there's the article by law, that's at 16,625 in the record. The author used computer simulations to see which forestry strategies increased carbon sequestration. This was not an analysis of negative impacts associated with carbon sequestration or timber. They were looking for what strategies made the most difference if your goal with your trees is to sequester carbon. Based on her computer simulations, law log, head of research proved the following. These are the things that are most effective in increasing sequestration. Replanting trees after fire, extending the rotation age, reducing timber harvest, which makes sense. If you harvest timber, you are taking trees out of, they stop sequestering carbon. But under her analysis, you can also replant them. Now, she concludes that these are things that will improve carbon sequestration. But under SEPA, that's not the correct analysis to use. We are not asked whether or not the project improves the environment. What we do at SEPA is to look at the environmental impacts. DNR is not required by law to improve sequestration. DNR is required by law to sustainably manage its forests so that there is no delayed curtailment of wood products coming from its forest. That is our marching orders at this point in time and will continue to be unless that statutes change, that we manage timber harvest on a sustainable level with no curtailment of production. And that is done because it provides a steady stream of income and it's fair to all the classes of beneficiaries. We can't just stop logging trees today because we want to grow them safe. We want all our trees to grow for 100 years. Well, that means that beneficiaries 100 years from now will have there'll be trees available for harvesting, theoretically, 100 years from now. But what do we do about the beneficiaries between now and then? We need to treat all beneficiary classes equally. So we harvest some over time on an equal basis. Now, the Washington Forest Ecosystem Carbon Inventory, that is referenced in the letters, that's a DNR document, so that's something we could look up and look at. They assess carbon fluxes, the rate of sequestration and emissions over time, and it concluded that forests were a sink of carbon sequestration. And it showed that the DNR lands and private lands actually sequester at a higher rate than do the federal lands, which have far fewer timber harvests than do the state and private industrial forestry lands. In Smith, it's in the record at 12659. That's the starting page. It's detailed discussion. The U.S. Forest Service, or an individual in the U.S. Forest Services, went through and created lookup tables. So depending on your region and depending on the type of wood you were working with, you could calculate the emissions of wood over time. So that information, you can look that up on the lookup tables. But that proceeds under the assumption. The reason they did this analysis is because they were concerned that if you just count emissions at the harvest level, it looks as if all that carbon is emitted in one. You need to count the carbon that goes into wood products. It's held in those wood products for an extended period of time in some cases, for a shorter period of time in other cases. And he did all sorts of statistical analysis. I really can't understand it all, but he did the analysis. And DNR used his analysis when it did its regional computation of the impact of harvest on the global climate. I'll read to you from page 12663, which is in the Smith article, carbon is sequestered in growing trees. Accrual of forest ecosystem also depend on accumulation of carbon in dead wood, litter, and soil organic matter. When wood is harvested and removed from the forest, not all of the carbon flows immediately to the atmosphere. In fact, the portion of harvested carbon sequestered in long-lasting wood products may not be released to the atmosphere for years or decades. If carbon remaining in harvested wood products is not part of the accounting system, calculation of the change in carbon stocks for the forest area that is harvested will incorrectly indicate that all harvested carbon is released into the atmosphere immediately. So that is why he made those lookup tables, to help land managers estimate carbon. Now, they did not reference the Climate Action Committee's study of Jefferson County forests in their letters. They did include it in their materials, however, and it was very interesting. It proved DNR's point. The Climate Action Committee looked at the forests, it looked at the timber that was harvested, mortality, fires, it took disturbances, it took that into account, and it concluded that the trees in Jefferson County, the forests, are sequestering many times more carbon than is emitted from sequestration. That's looking at it at the county level. Now, plaintiffs insist that it needs to be done at the unit of a timber sale, but that doesn't make any sense to me because it's a sector-based analysis where they look at usually ownership of the forest over time to see how the forest has been disturbed. Does the amount disturbed, say, from harvested lands, does that amount exceed the amount that is being sequestered? Then it's not a sustainable harvest, because sustainability means you don't take more than you grow. In DNR's case, we take much less, we grow more timber than we harvest. So I think if DNR, and this is, I think if DNR had this next piece, they would have answered the letter differently, but they didn't get it until the end of January. It's the Center for Sustainable Economy. It appears to be a white paper. It's advocating a certain, it's an advocacy piece, not a scientific article, but it's advocacy by the center. It's criticizing forest carbon policy. And it's really the only material that provides any insight into the rationale for their insistence on this useless number of emissions from a particular timber sale. Appellants oppose the methodology used by the International Panel on Climate Control, the U.S. Environmental Protection Agency. The forestry sector should not be allowed to use the sequestration of forests to offset carbon emissions with harvest. That is the policy position that they took in Oregon at that time. And it appears to be the same position they're taking at this time, except they're not saying so. Now I understand why they just want the carbon emission figures. They want to add them all up and say, look at this huge carbon emission, and ignore the fact that it is counterbalanced by a vast amount of sequestration that is going on in forested lands. They oppose the concept of net, meaning you have emissions and you have sequestrations. The difference between the two is your carbon footprint, so to speak. So if you are sequestering far more carbon than you are emitting, you are a net sink. You're doing something good for the environment. Now, yes, if you just left all the forests uncut, they would do even more sequestering. But that's a policy choice. That's not a choice we have in front of us right now. DNR has to cut trees and provide sustainable harvest. That's how the legislature has directed, and that is what DNR is doing within the confines of its policy and legal framework. And also, it is the approach that the state of Washington will be taking with other emitters of carbon. Say, for example, a cement company making cement causes the release of a lot of carbon dioxide. They will be given allowances so that they can balance that. They can emit carbon dioxide up to that amount. If they need to emit more, then they need to go purchase additional allowances, or they need to do carbon mitigation. And I think plaintiffs view the forests as they're great, this great sequestration. Think of all the good it could do. Well, that's not the legal basis to attack it under CEPA. That's really a policy argument. What you need to look at under CEPA is there something in these two timber sales that would lead anyone to believe, given that background, given the scientific community, given how the UN and the International Panel on Climate Control and the EPA and the State of Washington Department of Ecology, and how everybody calculates the carbon for the forestry sector. Is there anything different about these two timber sales that would lead you to suspect that the trees in this forest were suddenly going to emit far more carbon than that is being sequestered by the forest? And the answer is no. And it's not just the fact that there's a carbon emission. You need to tie it to an environmental impact. Yes, carbon is emitted from cutting these trees. Yes, DNR can do the calculation. They could do it as well. Anybody could do it. You could sit down, do the lookup tables, and figure it out. But is it useful information? Does it tell you anything about a foreseeable, likely impact? CEPA does not require DNR to analyze every conceivable environmental impact. DNR is only required to analyze the likely and foreseeable impacts, not the remote impacts, not the hypothetical impacts. So, why? Why is it the limitation? Well, it's the decision maker. Is it useful information to the decision maker? And emissions alone are not useful information to the decision maker. What is useful is look at DNRs, take the cumulative effects of logging. Cumulative effects are important under CEPA. You look at the logging you do on your lands, and you look at the forest that remains and grows during the time period, and then you see if emissions exceed sequestration. If you're doing a good job, then the sequestration and the emissions will not exceed if you're sustainably managing the forest. Now, DNR points out in its response, look, 40% of our, we leave a lot of forest unharvested. We set aside 40%, almost 50% of our lands are set aside either for habitat or for some other reason. So those remain available to continue sequestration. Those also what remains available for sequestration are all the trees that DNR replants. Now, it's true that young trees really don't sequester that much carbon, but as they age, they will. They grow to a point, and then as they reach their maximum, the maximum size that the species can reach, they taper off. So it really makes sense to have the forest in different phases so that you're always having some group of trees sequestering carbon, not cut it down all at once. That would be illegal. That would be That would be something that would need an environmental impact statement. But you need to look at these two timber sales. Is there anything in them? Have appellants presented any information that leads the court to believe that DNR, firmly believe that DNR made a mistake in not calculating the emissions? They make this big deal about emissions, then they make a big deal about climate change, and I agree with them. Bad things are happening in climate change, but they haven't drawn the link between the two events. Two timber sales in Washington, two relatively small timber sales versus global climate change. And none of the materials make that link. In fact, they confirm DNR's belief that sustainably managed forest sequesters carbon. So long as you check, and every 10 years we do a sustainable harvest level, and we will again, we will start one again. DNR will be building into that process an evaluation of the impact on climate. And we look at it not only for the next 10 years, but the next 100 years, as is demonstrated in the exhibits. The final environmental impact statements for both the forest, sustainable harvest yield, and the long-term conservation strategy for the Marlet. That's all that I have.
Ms. Newman, reply.
Thank you, Your Honor. That entire conversation was an analysis that the responsible official did not do. And we're asking the court to remand it for the responsible official to do that analysis, not the attorney for DNR. And we did show, contrary to what the assistant AG said, that the emissions would have significant adverse impacts. The logging in Jefferson County is the #1 source of emissions in the county, and that's site is in our brief. We've actually put quite a bit of information in my opening brief from pages 23 to 27, I believe, outlining the significant adverse impacts that logging has. And I was especially frustrated to hear the argument that we didn't tell them that they were doing it incorrectly, because how could we possibly have responded and said your analysis is incorrect when they didn't do any analysis at all? I read what was in the environmental checklist out loud. That is the information that we had in front of us to comment on. And so this extremely complicated analysis had not been done, so it's impossible for us to have possibly told them that they were doing it wrong when it hadn't been done yet. And that's the whole point of this appeal. A lot of conversation revolved around this idea that when you look at the big picture, the carbon sequestration is more than the carbon emissions. When the DNR was analyzing overall the impacts that they have on climate change, and forests are a sink of greenhouse gas emissions. Now, first, I want to point out that that's over 100 years analysis, which is a really long time. And second, that's the analysis that was in the policy documents. And we disagree with the methodology because basically what you're doing is you're using the existing baseline that's going to exist no matter what, as if you get that as a positive in your, it's like an oil rig, you know, on an ocean, setting up a new emissions, source of emissions, greenhouse gas emissions, and then saying that all of the ocean is actually, they can count that as counteracting what their emissions are. And under SEPA, it doesn't work that way. What happens is you have an action that you're proposing, and what you do is you look at what the impacts are of that action specifically. You don't look at the rest of the world and how other things may be counteracting against your actions. And I think most importantly, that broader look at the world, while it you know, even if, let's say, you know, DNR convinced this court that it was appropriate to look at it at the big picture, it's definitely not appropriate to look at it from the big picture at a project level. Because at the project level, you are looking at a specific project with concrete information. Can they preserve the Sitka spruce or the western hemlock, which appear to be less vulnerable to climate impacts than other species, when they know exactly what species they're working with? Has this particular section of the forest recently suffered from insect outbreaks, wildfire, or other impacts from climate change? And how are we going to address that specific issue that's right in front of us? Is it more vulnerable to wildfire? Like, what is the makeup here? What species do we have? Is it silver fir? Because that's more vulnerable to climate change impacts. And so you have this project in front of you, and you have specific, this is all modeling based on a massive big picture. And now we have this site-specific project, and you can actually make changes, as I talked about the substantive SEPA. If DNR looks at climate change impacts at a project level, they might change tweak the project a little bit. Of course, they need to cut the trees. That's, as you know, the legislature does require trees cut, but you can make changes, like for example, maybe set aside certain portions of the timber sale and get paid through carbon credits, if that's something that would make sense. Maybe you should employ variable density thinning in certain portions instead of this variable retention harvest technique. And I want to point out, this was an aside, but in the brief, DNR made it sound like variable retention harvest techniques, which both of these projects are using, was actually, you almost, after reading their description, you would think half of the forest was still going to stay there, but it's far more closer than a clear cut, and they're in the record. I do have a reference to the Forest Land Plan, which is 4474 and 4475, if the court is interested, in the distinction between variable retention harvest, which we submit is like a clear cut. And what we're asking them to consider is variable density thinning, which is going in and thinning out the forest, which is a much better approach for climate. And clearly we are not asking the court to suggest any of this. The reason I'm bringing this up is that this is why it's important to send it back to the responsible official to do a project-specific review, because these are ideas of potential, why it matters. I'm just explaining why it matters. If they go through the process, they might consider mitigation associated with the site-specific project now that they have this specific information in front of them. So it's very different from a broad level review. And I didn't hear a lot of reference to the law in DNR's argument. And I heard a description of saying plaintiffs want this, plaintiffs want that. And really what we're talking about is what the law requires. And it may not make sense, as DNR's attorney said, it didn't make sense to her, but the law actually requires that there be a review of climate change impacts at the timber sale level. That's just the whole point we're trying to make. And I do, as an aside, want to point out that it does matter that they failed to incorporate the FEIS, which is something I pointed out earlier, that the environmental review did not even mention the previous FEISs, because the law requires it under WAC 197-11-600 and 197-11-060 sub 5, which I also briefed. And I noted that DNR has admitted that it was not incorporated, but basically said it doesn't matter. But you know, we can't just disregard what the law requires, just outright and say no harm, no, you know, it matters to follow the law, because that comes back to the idea that we didn't know, you know, we can't call them out on making mistakes when we don't even know what the analysis is, when there's no analysis in front of us to comment on as members of the public. So overall, it's just not fair to say that the analysis isn't required because they did it before, that these impacts are remote, and that, you know, we don't even have to worry about it or think about it, because it really does make a huge difference if DNR does this analysis for timber sale, specific timber sales, or does not. And they seem to have a policy right now of not doing that, and that's a violation of CEPA, so we request that the court remand it and require that analysis. Thank you.
I just have a couple of questions here. First of all, I'm curious, as I read through this stuff, have other timber sales similar to this, either on the peninsula or throughout the state, have other DNR timber sales such as this, have they been challenged like this under CEPA? Or is this some new development?
I don't know, yeah. I mean, that's outside of the record, and I don't think it would be appropriate for me to answer that, because I could speculate, but.
Okay, you're right. It's not in the record, so never mind.
I'm told that my client has challenged other timber sales.
Okay, when they went through and did the analysis below, they did not refer to the 3 EISs that were done. And so I'm just curious, how did those become part of the record then if they were not used down below?
I would argue they were not part of the record, and I did not compile the record myself, but I do think they're inappropriately part of the record.
Ms. Thompson?
Under the statute 7902-030 is a unique statute. It allows people to challenge decisions to sell or lease land or valuable materials from the land, and the agency compiles the record. We compile all the information that we have up to the point of the board's decision, and that is the board's record. We included additional materials that came in after the decision, because at least they could make so we could figure out what their arguments were, what they based their set of beliefs on. But really, they shouldn't be part of the record either. None of their materials should be part of the record, except for the fact that they really do support DNR's position. So I left them in the record.
Okay, Ms. Newman, one of the statutes I looked at, and it was referred to, I think, in both your briefs, about the idea that, well, usually in a threshold determination, you don't need to consider alternatives. However, maybe considering alternatives is appropriate if there's a situation where where there are conflicts in connection with what's being considered. You didn't mention that in your argument, and maybe it's not particularly relevant, but I'm just curious.
Very relevant, and I appreciate you bringing it up. It's very relevant.
Oh, okay.
And do you want me to approach?
Okay, if you could.
The statute says that even if it's a DNS, you have to study, develop, and describe appropriate alternatives to recommend courses of action in any proposal which involves unresolved conflicts regarding alternative uses of available resources. And I think this hits that on all fours, that there are unresolved conflicts about how to alternative uses of available resources. And the case that really recently Supreme Court of Washington interpreted this language in the Wild Fish Conservancy versus Washington Department of Fish and Wildlife, 198, Win 2nd, 846. And there's a nice extensive description of what that language means. And it's about whether there's a direct conflict. That was about species of fish and whether they were choosing one species over the other, and there was a direct conflict over that choice. And here I would argue it's the same thing, where there's a choice between conserving the resources or variable thinning versus the clear-cutting type method that they're doing.
Okay.
So I thought that, I really appreciate you raising that.
Okay. Ms. Thompson, do you have any comment on that issue?
Yes, Your Honor. They correctly cite the Wild Fish Conservancy case. That is the case that teased this out. There was I think prior to that, there was a Pollution Control Hearing Board case. But I think if you're looking for authority, citable authority, I would stick with the Superior Court, or the appellate ruling, Supreme Court ruling in the Wild Fish Conservancy. They held under the provisions of SEPA, requiring branches of government to develop and describe appropriate alternatives to recommended courses of action in any proposal which involves unresolved conflicts concerning alternate uses of available resources. The competition must be unresolved and unsettled. So in that case, the Wild Fish Conservancy opposed the Department of Fish and Wildlife allowing Cook Aquaculture to replace its Atlantic salmon farm fish with steelhead, or should I say rainbow steelhead, in the marine environment. They already had the permit for the site, and they were changing the dish, and the court said, this is not a case of an unresolved conflict. Now, where you might have an unresolved conflict in terms of a net pen would be if you have tribal fishing. It's a great tribal fishing right. It's a great place to take place. Maybe it's the only place where this certain activity can occur. And you want to put a net pen out there. Well, I think you're going to do an EIS. You're going to do environmental impact, but if you could do a determination of non-significance, you would be required to deal with that issue of either or. If we put this net pen here, we cannot engage in this tribal fishing activity. That's an either or situation. Now, they may have a fondness for this particular patch of wood, but there is nothing really unique about it. There were some unique habitat types, and DNR mitigated for those by excluding them from the site and clumping leaf trees around them. I think it's the Goodman site. They protected some caves and some balds. It's a rocky ground that only grows certain kinds of plants. That's protected habitat. They wanted to protect that. So if you have a unique habitat, then yes, that sort of information would come into play. It would say, if we cut trees here, we destroy this. And DNR has policies in place and procedures in place to prevent that from happening. And they describe all that they do in their checklist. Everything they did to protect, they were looking for likely impacts, likely adverse environmental impacts. Changing the climate just is not likely from 2 small timber sales. And you don't get to county emissions unless you can show that the emissions are of such a magnitude that they would overshadow any sequestration occurring so as to contribute meaningfully to the concentration of carbon dioxide in the atmosphere, which stretches around the world. So they insist that emissions need to be analyzed, but that's not true. It's only if there are emissions, there's something about this timber sale that is, for example, if DNR, instead of leasing this land or harvesting timber, decided to, well, this would be a great place to extract natural gas. We're going to lease this land to someone who's going to extract natural gas. If we were to lease to them, number one, I think you'd be doing an EIS. But setting aside, that is a situation where you have emissions that will come from this. And the discussion is it the emissions of manufacturing the gas, or do you go down the line and look at the emissions of that gas as people use it to heat their homes? And in the federal context, of course, I said yes. If you are allowing them, if you give them the right to extract fossil fuels and burn and process them to be burned, you have to look at what's going on. You had to count those in. Other federal cases looking at timber sales said, no, this is not that kind of case. The carbon from burning fossil fuels is different than the carbon from trees. Carbon from trees is natural. It's a natural part of the environment. Timber sales just take that, what naturally would have decayed anyway. The trees would have died eventually, over time, maybe 100 years, but they would have eventually died, and they would have emitted that carbon. DNR just interrupts that cycle and stores that carbon in hard and wood products.
So, okay, just a minute.
Possibly rebut just briefly the,
Oh, that's okay.
okay.
Okay, in the Wild Fish case, and I'm not finding the statute right now that I thought I had here, but anyway, in the Wild Fish case, it says the State Department of Ecology was designated by the legislature to interpret and implement SEPA, and thus, and because of that, because DOE was so designated, the Department of Fish and Wildlife was not entitled to special deference by the courts. You both argued about this in your brief. And so under the WAC 714, it defines agency and explains that an agency with environmental expertise means these that are listed on this list, and for the categories that they are designated for. And I'm not gonna go through the list. There's 4 items where DNR is designated as having some degree of expertise. Ms. Newman, in connection with this, is DNR an agency that, that is entitled to special deference?
I'm sorry, what was the citation? It was 17711?
Well, 197.11, 714
714.
that talks about agencies with environmental expertise.
Oh, okay.
And then the designation of those agencies that have special expertise is in 197.11.920.
Okay.
So I'm just curious, is DNR an agency with expertise concerning the issues involved here?
No, Your Honor, because the regulations that I refer to regarding the process for SEPA review and the phase review requirements, which are all in WAC 197-11-600-060, there are several that I've cited in my brief, are all Department of Ecology regulations about how the SEPA process must be followed. And if you look at the Wild Fish Conservancy case, they made that distinction in there, specifically referring to those regulations being DOE regulations. And those are the regulations we're relying on in our appeal. There are no DNR-related regulations that need to be applied or interpreted here.
Ms. Thompson, do you have a view on that?
I would agree that the standard under SEPA for determining whether the threshold determination is appropriate is the clearly erroneous standard. There is some degree of deference, but only in the area of the agency's expertise. In that case, they were arguing about how to construe SEPA and the SEPA rules. Ecology would have been the expert, not the Department of Fish and Wildlife. In this case, I agree. Ecology is the expert on SEPA. DNR expertise lies in the area of forestry.
Okay, then related question, under the statute, 4321C 090, it basically says that the decision of the governmental agency shall be accorded substantial weight. I take it in connection with, well, various decisions, but whether or not to require an EIS. How do you read that as it applies to DNR?
I agree with the court that the weight is not as substantial because of the Wild Fish Conservancy reference. As far as deference, I think that they overlap and coalesce there. I also want to point out that courts have looked at that substantial weight language and equated it with the clearly erroneous standard. And so I don't think the fact that the court is applying the clearly erroneous standard in the first place kind of already is giving substantial weight. They're kind of the same thing. And clearly erroneous standard is actually a more increased judicial scrutiny standard than arbitrary and capricious. And so if there is a clear error, the court has, if it's clear to the court that an error has been committed, the court has the authority to, does not have to defer to the agency.
Okay. Okay, well, I've spent a lot of time on this case over the last number of weeks, and And ultimately, when I got through everything, I felt like I was dealing with a moving target. And so I'm gonna make my decision right now, because I've done enough on it already to know what I'm gonna do. But I felt like I've been dealing with a moving target, because when I looked through the determinations of non-significance and read the appeal, notice of appeal, and looked at the checklist, okay, then I reviewed the plaintiff's brief, and it basically, basically they raised a couple of issues about SEPA. And so, and based on the DNSs and everything I read, I thought to myself, okay, the state's gonna come back and cite some authority and so on and so forth, that's gonna say, oh no, they didn't have to do climate change analysis or the things related to that, and here's why, what they did was proper. But instead, what I got with the state's brief, and the plaintiff pointed this out in its reply, I got basically an environmental analysis of these sales and about all the environmental measures that the DNR goes through to make sure that, the forests are sustained and roads are done properly and drainage and all these things are all great. And then they referred to the three environmental statements that were done in connection with the three other studies or policy determinations, and said, we don't need to do it now because all this stuff was looked at back then. I went back and looked at all the climate stuff in those three EIS documents. And when I read that all through, I thought, oh, this is really good information. Too bad none of it was part of the checklist or the DNS determination. And the plaintiff in its reply, I think it was in its reply, one of the things that the plaintiff said was, gee, we're not asking the court to get down in the weeds and make all these determinations about environmental impacts and everything else. And I appreciated that, because the state's initial brief, other than the argument about, oh, there is substantial adverse impacts from greenhouse gas emissions and climate change, even though they went into that, then in their reply they basically said, but no, we don't need to go there. We're looking at the SEPA process. And today, the plaintiff has reaffirmed that, and they said, simple case, actually a fairly simple issue, and whether or not there's adverse impacts and all that stuff, that's a decision for the responsible official to make, and not one that I have to make. But then, today, from the department, I heard a whole lot of analysis and a whole lot of references to the record and everything else about various studies and sequestration versus emissions and all that stuff. And so what's interesting to me about all this is, and the plaintiff was right on this point, the checklist says what it says. The elements of the environment says what it says, and the elements of the environment include air quality, climate, and so if somebody was ambitious or somebody wanted to dot the I's and cross the T's, it would make sense to me that, gee, on the checklist under the category of air or climate or whatever, maybe somebody would mention and discuss greenhouse gas emissions and climate change, because it's certainly been made a big deal now for several years, and in fact, one of you cited it in your brief, the preamble for the recent statute dealing with climate change and all that. And I might have thought that the people that created the checklist for these two sales, that they that they might have referred to the 3 EISs that were done that supposedly justify their decision to approve these sales without really any further review concerning greenhouse gas or climate change. The issue is not whether I agree that, oh gee, these two sales should never have been approved because they're gonna have an adverse effect on greenhouse gas emissions and climate change. And it's also not my decision to say, oh, they didn't need to review those things because, oh, there's no way 2 little timber sales here in Western Washington are going to affect global climate change and greenhouse gas emissions. That's not my role, and I'm not going to decide that today because I don't know. But what I do know is that in the checklist and the discussions I read and the documents I read and then the DNSs, there was absolutely no reference whatsoever to greenhouse gas emissions and climate change impacts or possible impacts or anything about it. And I didn't see any authority that a case or a SEPA rule or anything like that that said something to the effect of, oh, well, if we all know something's not a problem, we don't need to discuss it. No, in the checklist, there has to be a reference to these things, and if there's not a problem, somebody can write in the checklist, there's no problem because of A, B, C, and D. Or, on the other hand, if they determine there is a problem because of, H, I, J, K, or whatever. And none of that was done here. So I don't want to be a fly in the ointment or a wrench in the works, but and another, then, during the argument today, there was reference to the center's correspondence or some of the comments or something were late. Well, I don't know. I didn't go back and make a timeline and figure out what was filed on time and what was not filed on time, and I don't know whether I'm supposed to take that into account or not. The state indicated today, oh, but it doesn't matter because it doesn't change anything. So, as far as I can tell, the plaintiff pointed out that the problem with none of this stuff being raised and none of these prior documents being referenced or incorporated by reference or adopted or anything is that presumably or theoretically it really limited what was sort of out there for comment. As I understand it today, the plaintiff is asking that the court invalidate the board's approval of these two sales, invalidate the determinations of non-significance for each of the sales, and simply remand the matters back to DNR to properly analyze greenhouse gas emissions and climate change in connection with the checklist and the threshold determination. Is that accurate?
Yes, thank you.
And there was some reference in the materials that, okay, DOE one of these days is gonna get around to updating the checklist form. And the checklist form, I think, is a form that goes back to 1984 or something. I mean, it apparently hasn't been changed for some period of time. But, in just a minute. But as I said, under section 444 of the regulations, it refers to air quality, and climate, and the DOC website, there was an entry from there having to do with air, where it talks about what types of emissions to the air would result from the proposal. And at the end it says greenhouse gas emissions are considered an air pollutant and may need to be addressed. And the environmental checklist itself refers to air and emissions, and what the scope of that is supposed to be, I'm not going to decide today. The plaintiff is basically saying that, oh gee, there's going to be emissions from the very first time somebody starts up a logging truck and heads onto the property, all the way through the processing of the timber in some mill, you know, wherever that ends up being. And as opposed to the state's checklist, which pretty narrowly limits the issue of emissions and so forth to, well, just simply to what's happening there during this logging operation and nothing else. Just a minute. And in the case, and I've got it here somewhere, I think you both referred to it, but there is a case that specifically says that climate change is a factor that should be looked at. And that case said that regardless of what the checklist said. And finally, oh yeah, the Washington State Dairy Federation case. And finally, yeah, I mean, these previous documents can be used, but there's a process spelled out in 197.11.060 about phased review and using existing environmental documents and so on. And I think 197.11.600 is relevant to that. And the statute 4321C034 refers to use of existing documents. Yeah, 197.11.600. as well as the discussion about Bay's review in 060. So bottom line is, I think what was done was clearly erroneous, and I'll sign an order granting what the plaintiff is requesting here. And all I'm saying, I want to make this clear, all I'm saying is that they just need to go back and do the SEPA process properly, and, because I don't think it was done properly. I'm not making any judgment whatsoever on the merits of these sales or the environmental consequences or anything at all, in that regard. And my guess is my decision's gonna be appealed, and it would be appealed no matter which way I ruled, so if it doesn't go back to DNR to start over, maybe I'll read about it in the court report someday. Anything else, Ms. Newman?
No, thank you, Your Honor.
Ms. Thompson, anything else?
No, thank you, Your Honor.
Other than, you're dead wrong. Maybe, I don't know. Okay, thank you.